Mr. Majeed Memon.
Honorable Sir, the subject, namely the Law and Justice Ministry, the administration of justice, and the issues connected with judiciary, is so vast that it would require me at least an hour even to touch every subject out of it. But then, since I have only a few minutes on hand, I'll only be touching the tip of the iceberg. The Honorable Law Minister may please make a note that the goal for success in this direction is to have speedy and inexpensive justice to the less fortunate Indian populace, more particularly a large number of poor litigants in villages and in remote places. What best can we do with limited resources and means to ensure that justice visits upon the people who are unfortunately so placed as villagers in remote villages, poor people who cannot afford to even travel to the courts? Friends, Honorable Chairman, when we talk of inexpensive justice, we will have to ensure that there is a provision under the code of providing free legal aid. I am sorry to say that our experience tells us in various courts all over the country that the concept of free legal aid is a mere paper tiger. Hardly any worthwhile assistance is being extended to the needy poor who need in true sense legal aid. I think we will have to very seriously examine the mandate of our Constitution or the Code of Criminal Procedure in directing us that let us provide free legal aid to less fortunate litigants who are large in numbers and who succumb to injustice either at the lowest court or in the first appeal court, but they seldom can reach Supreme Court for want of funds and want of means. And when we talk of speedy justice, lots have already been spoken about delay and backlog of cases, which I need not repeat. All figures are before us, and we are looking down, with a sense of guilt that we are not able to deliver justice in time. And as rightly said, justice delayed is justice denied. The latest example, the Honorable Chairman, sir, I would place, which is making me hang my head in shame, is that 1987 incident of Meerut. The trial ended in 2015. You can imagine 28 years for a case of 42 multiple murders could take 28 years for wind up in a trial court. What is this? As many as 19 accused persons who were all provincial armed constabulary men had to be acquitted because it is very difficult to get evidence after more than 2.5 decades in establishing a case or reaching the bottom of truth. Now this is nothing but failure of justice. And this is just one instance. There are a large number of cases in our trial courts where murder trials, rape trials, dacoity trials are waiting for disposal, for hearing for over 10 years or 15 years. This is nothing but mockery of justice. And our prisons are overflowing with a large number of people who cannot afford bail. Where do we call our equality before law? How can we claim that we are doing justice to everybody when a poor who cannot buy bail because he is not solvent enough? You have to buy bail even in this 21st century when we talk of free legal aid, when we talk of dispensing justice to everybody and treating everybody alike. Our prisons are overflowing with under-trial prisoners. The Honorable Home Minister Law Minister will please make a very serious note of this fact, that how many under-trial prisoners are languishing in prison beyond the period prescribed for ultimate punishment, even if they are found guilty. It's a matter of shame. I think we will have to suggest something whereby we can decongest our prisons, and I am suggesting briefly that as far as bail applications are concerned, we need to have a relook at our bail procedure. As rightly pointed out, that bail restoration of personal liberty to a presumably innocent person is the mandate of Constitution. And we must all assure that under trial prisoners stay in prison waiting for justice should be minimal. And how can we do that? I am sorry to say that in large number of courts all over the country, bail applications are not being heard. Bail applications are kept pending for months and months. This is something shameful. And I am therefore suggesting that in offences which are not punishable with death or imprisonment for life, for all lesser offences, there must be a mandate of law that bail applications must be decided within a short spell of time, say 2 weeks or 6 weeks, so something reasonable. And if bail applications for certain genuine reasons cannot be heard and disposed of, at least interim bail should be given to the man who is seeking bail if your administration is unable to dispose of his petition. I am afraid that unless we take effective steps to ensure that our prisons do not anymore overflow with under trial prisoners, we cannot be called a civilized country, because, as rightly stated, that a country's civilization can be best gauged by the effectiveness with which its criminal justice system functions. And we are a failure as far as our criminal justice is concerned, more particularly in cases of teeming millions, poor people who cannot afford good lawyers, who cannot approach higher courts. So I think the Honorable Law Minister will examine this aspect and take suitable steps here. Thank you.
Thank you very much.